Waiting for everybody to join. Thank you.
We'll roll call in a moment here. Stand by. Good afternoon, good morning. We were here a little bit late last night, but it's a good thing we didn't stay till midnight. So I will call us back to order. Again, this is a continuation of Tuesday's council meeting, which just has two time-specific items left, particularly the sanction process complaints in 6.6 and the separate complaints in 6.7. So we are here to hear those in that order, but I need to roll call to establish attendance. I understand we'll have some absences this morning. We'll note those as we go. But let's start with Councillor Henderson.
You caught me by surprise. I'm here.
Good morning, Councillor Knack.
Good morning.
Good morning, Councillor McKean.
Good morning.
Good morning, Councillor Nicol. Councillor Nicol? No? Okay. How about Councillor Paquette?
Good morning.
Good morning, Councillor Walters.
Yep, I'm here.
Good morning, Councillor Bankett.
I am here, thank you.
Good morning, Councillor Cartmel is
Good
live and on deck here in the building. Good to see you. Councillor Katarina.
Good morning.
Good morning, Councillor Zadig.
Good morning.
Good morning, Councillor Essinger.
Good morning.
And Councillor Hamilton let me know she has a medical appointment this morning. Won't be able to join us. So that's 11. That's enough to get started. I think Ms. Pytel is...
There might be a speech right in front of you, if you wouldn't mind terribly.
Yes. Thank you, Madam Clerk. So there are two sanction hearings today, and it's very important that the two matters be dealt with very distinctly and separately, and they cannot be, therefore, cross-referenced today. The purpose of items 6.7 is to decide on potential sanctions that may be applied to a member of council who's been found by the Integrity Commissioner to have substantially breached the Council Code of Conduct. City Council has received reports from the Integrity Commissioner outlining the facts and findings as they relate to this breach of the code. The role of City Council is to deal solely with potential sanctions. Questions relating to the process to reach the results and the recommendations are acceptable, as are clarifying questions as to why an action violates the code. The purpose of this meeting is not, however, to question the findings of the Integrity Commissioner. Instead, it is to ensure that the process was reasonable in relation to the severity of the breach, in that the process was fair, transparent, and rational for such a breach. If we believe the process was reasonable, then it is also our place to determine whether to accept the proposed sanction outlined in the report, or to find that a different sanction, or no sanction at all, is warranted in these circumstances. Given the slightly unusual nature of this item, it's my role today, and the role of our legal advisors, to ensure that we do not stray from our assigned duties. It is possible that some of us may disagree on whether the conduct should have been found to be a breach, and while this view may ultimately impact our decision on the severity of any penalty, we cannot make a finding that no breach occurred, as that is very clearly the responsibility delegated to the Integrity Commissioner. We are not here today to ask our ethics advisor or the Integrity Commissioner to provide ethics advice to individual councillors or to ask how the code could be interpreted. Lawyers from legal services are also here today to assist council by providing legal advice if needed. If through this discussion any member of council feels that our code of conduct needs to be clarified, that is fair, but it is not the role of City Council to debate the code today, and any motions on this would not be in order. In making a determination on sanctions, we must put aside any personal biases we may have, including personal disagreements with other members of City Council. Instead, we must form opinions based on the submissions made by the councillor involved and the facts and evidence that are put for us today in the findings. In a sense, we're acting today not as councillors representing the city, but as the entity that is given the important responsibility of rendering a penalty against one of our members. In this sense, we may be taking on both administrative and quasi-judicial roles. So we must remember that we are accountable to ourselves, to each other, and ultimately to the citizens of Edmonton in any decision that we make. The process we will follow for the sanction hearing is as follows. A presentation from the Integrity Commissioner, then questions of the Integrity Commissioner by members of council, including the respondent councillor, if they wish. Submissions by the respondent councillor or council, up to 10 minutes. If the respondent councillor needs additional time to present a meaningful response, then council may allow the respondent councillor to speak in additional 10-minute increments by motion. Then, fourth, questions by members of council to the respondent councillors or their council through the chair. 5, council determines if it will hear from speakers with a direct interest in the sanction hearing. Usually, the usual 5-minute limit for speakers will apply. 6, questions of speakers, if any, by all members of council, including the respondent councillor. I don't think we have any registrations to speak today.
No, we do not, Mr. Mayor.
And then the motion on a sanction is put on the floor. Then members of council other than the respondent councillor speak to the motion on the floor for up to 5 minutes, and then the respondent councillor or council may speak to the motion on the floor for up to 10 minutes. And again, if the respondent councillor needs additional time to present a meaningful response, council may allow the respondent councillor to speak in additional 10-minute increments. And as per the Code of Conduct Bylaw Schedule C, a reminder that the sanction motion requires a special resolution to pass. So that is the process for the first hearing, and it will also be the process for the second hearing when we get to it, but again, it's critical that we keep those distinct and separate. So, Ms. Pytel.
Good morning, Your Worship and members of council and administration. I thought I'd start by giving you a brief update in terms of this being an election year, and the item 6.6 deals with violations related to campaign activity. And so I just wanted to remind council that we met earlier on in the year to discuss how the code still applies even during a campaign period. And council was reminded specifically with respect to the use of email addresses in campaign activity. Now, I've received a number of complaints, and that's item 6.6, so I've received 4 complaints. There were other complaints that were similar that were dismissed or didn't go forward, and I raise that because there is a history with respect to these complaints. I do want to mention to council that we are, because this is an election year, approaching a blackout period where I will and am suspending all investigations. I have no outstanding investigations right now except those with respect to Councillor Nicol. And given the time that's approaching the blackout period, unless council directs me otherwise, I will not be doing any more investigations, and there will be none done until after the election. And that is a decision that was made by council when you passed the code, that there should be a period, but the period starts imminently, and now there's no time to actually do proper investigations and give responding councillors an opportunity to respond. Either way, there's nothing in the hopper except what we're dealing with the campaign issues today. And as I said, nothing forthcoming unless council directs otherwise. Now, in my view, the passing of the code was relatively easy. I also think abiding by the code is relatively easy. What's difficult is, as Mayor Avison alluded to, is when you're in a situation of having to enforce the code. And so I don't bring code violations to this council lightly or easily, especially in an election year. I know the implications of doing so, and I take my responsibility to provide impartial, professional, and consistent services to this council. And today we are here because I have done my level best to provide those services in an impartial and professional and consistent way, applying the principles that this council agreed to in the code and applying the law if necessary. Now, these 4 complaints are brought by members of the general public with concerns that their email addresses that were obtained by the councillor's office for official duties were turned around and used for campaign duties. I don't bring these complaints forward. That there's a bit of a suggestion in this submission by Councillor Nicol that I'm somehow bringing these forward and targeting him. That's the opposite of the truth. I am obliged by law to respond to these complaints, and if they're within jurisdiction, I have no choice but to investigate. Here I found that, well, let's step back. The concerns around this type of activity went back to October of 2020, when I reached out to Councillor Nicol and advised him that there was a member of the public who was concerned that their email address had been obtained and used for campaign purposes. There was some information provided by Councillor Nicol, but not responsive necessarily to the code. Then in January, and that complainant didn't proceed, but Councillor Nicol was alerted to this issue. Then in January, complainant 2101 came forward, and I reached out to Councillor Nicol and told him of the complaint. We also had sessions with council in the beginning of the year to talk about how these 2 things need to be kept separate. I'm extremely mindful that this is the first year the council has had to deal with the code and an election period. So I gave Councillor Nicol an opportunity to respond to those concerns that were raised by a member of the public. In the meantime, more concerns were brought forward, which culminated in the 4 complaints that are before you. I repeatedly asked Councillor Nicol just to explain to me what happened, and perhaps we could get this resolved. And perhaps there was some miss that happened. I did not get responsive answers. I could not go back to the complainants and show them how Councillor Nicol had obtained their email address for purposes other than his official duties. If I was given that information, we would not be here. I regret to say, but I feel it's my obligation to tell council that in Councillor Nicol's submission, he suggests that he has answered these questions and provided the information that I've asked for. That is not correct. And to this day, the complainants involved insist that they've reviewed their records and they do not believe that they gave Councillor Nicol their consent or their email so that he could contact him for election purposes. This is simply a section of the code that needs to be abided by. So it left me with a situation of who to believe, so to speak. Councillor Nicol has suggested that I could have done more investigative work to deal with these issues, but there's nothing I can do. Councillor Nicol has told me he has the information. He just will not give me the details of that information. And without that, I can't dismiss the complaints. I can only believe the complainants when they say they didn't do this. So there's an issue around cooperation. There's an issue around raising concerns about this not being the right venue or jurisdiction. I've carefully researched and deliberately made sure that my jurisdiction is proper here. And I have no question around jurisdiction. These are not constitutional cases or criminal cases as alleged by Councillor Nicol. The Constitution doesn't apply to what we're dealing with here. His suggestion that he does not have to disclose is incorrect. There is an obligation, and he could have given me this information confidentially, and I assured him I would not share that information if it could compromise his campaign. So I'm in the difficult situation of bringing this to council, but it is on behalf of these complainants and not myself. And I'm receiving information from the complainants to today that they still do not believe that they gave Councillor Nicol this information for anything other than his official duties. Complainant 2104, in response to Councillor Nicol's submission, has said to me in an email that he's just asking for a fair election. He's concerned about the misuse of information, and he's concerned about an unfair advantage. Complainant 2106 appreciates the work that this office has done on this issue, but is assured that these matters will be taken seriously. Councillor Nicol raised a concern that these complaints may be brought in bad faith, but I have no evidence that they were brought in bad faith. Recall that we are in a political environment for sure, but if I was given evidence or anything by Councillor Nicol that would suggest the complaints were brought in bad faith, I would investigate and review and make a finding on that. I have no information to lead me to that conclusion. The only conclusion I can reach at this point is that Councillor Nicol has violated Part K, Section 5 of the Code by using email addresses obtained for official duties for his campaign purposes. Now, under the Code, I have an obligation to make a recommendation on sanction. And sanction is entirely up to council, as you know. And as I said earlier, I'm just an independent investigator. I've been described as an unelected bureaucrat, and that's not what I am. I actually work outside of the city of Edmonton. But in this role that I do on an hourly basis and part-time, just to clear that up, I do have to make recommendations on sanction. Here, I look at the various principles that you would typically take into account when looking at this type of violation. You look at the gravity and the potential for obtaining an unfair advantage in an election. You look at what I've determined as a refusal to cooperate or be responsive to questions that could have been answered. I look at the fact that Councillor Nicol knew about these concerns back to last October, and I feel I've given him a lot of time to address those concerns, and we possibly work through them. I believe it's an intentional disregard for the requirements of the code. And when we look at sanction, we consider the deterrence for this type of behavior if we're concerned about upholding the code. There are also previous violations that I have found in codes of conduct. They are progressive. So it's my obligation to look at whether there are previous violations, and there were violations found last year because they signal a potential disregard for the requirements of the code. So in closing, council, I've done my level best to be fair to Councillor Nicol, to be fair to the complainants, to fulfill the public interest that you've entrusted me with. And I have landed on 4 violations of the code with respect to the complaints that are in front of you. I am recommending a letter of reprimand with respect to these violations. But as I said earlier, that's council's decision to make. And I'm happy to answer council's questions.
Thank you, Ms. Pytel. Questions for Ms. Pytel? Councillor Cartmel indicates that he's trying to request, so, all right. The list in the order on the screen here is Councillor Banga, Councillor Knack, Councillor Cartmel, Councillor Henderson. Councillor Banga, go ahead. Councillor Banga, we can't hear you.
No, you can.
Go
Okay.
ahead.
Thank you. Ms. Pytel, when we are saying the blackout period, how is that decided and who does that? I don't
Councillor
know if
Bang,
it's a question I should be asking.
within the Code of Conduct, it says that investigations will be suspended for the 3 months leading up to the election. I checked with the city clerk, and there is not enough time now between July the 18th and October the 18th to properly investigate any further investigations, but I don't have any to investigate except 2 more that are related to the same issues that we're dealing with today that I've said I will suspend because it wouldn't give Councillor Nicol a full opportunity to respond. I haven't done anything with them because the code says that we are approaching a blackout period, and I need to ensure due process and fair process to anybody who might be investigated. And there are no other complaints in the hopper.
Okay, so if there is a violation of code of conduct within the 3 months of election, that would it be delayed or would it be completely not considered?
The code says that it may be suspended, and those principles are there so that there's not an interference with the election. I would be in council's hands in terms of whether they want that to continue or it says it may be suspended. That's good practice, and I believe council was right to put that in those provisions in the code. And there is a chance that if a council member was on council after the election, that the investigation could be resurrected, so to speak.
Thank you. And so today, what's before us is your part in this whole investigation is to declare whether this complaint is substantiated or not substantiated. That's all.
That's all.
And
Make
then,
recommendations on sanction, yes.
okay, but then, yeah, you are recommending. Is there any recommendation, or are you within your role to do any recommendations?
I'm required to make a recommendation, Councillor Banga, and my recommendation is a letter of reprimand.
Okay, thanks. That's all.
Thank you. Councillor Knack?
Thank you, Mr. Mayor. 2 questions, one of which, Ms. Pytel, you mentioned that there were some similar complaints that did not proceed, and I just wanted to get an understanding of the difference between the ones that didn't and the ones that did.
Well, Councillor Knack, I typically would not be talking about complaints that are before you other than to give context. I have 2 recent ones that are the same as this, and then I have an earlier one that didn't go forward. There was a fear that of
Okay.
providing
Right.
information, but it's really more just to set the stage that Councillor Nicol has known about these concerns for some time.
Okay. No, I was just wondering if there were. Thank you. That's enough for that one. The only other question I have relates to, I think it's complaints 2104, and in the redacted submission, there was a suggestion that this was collected via somebody that signed a petition. Does the code, and through, obviously you accepted it, but I just want to confirm, I believe our code suggests that any emails we collect, whether that be through an email list in our current rules or in the form of something like a petition, that then can't be carried over to a campaign. Is that why this one is here? I just wanted to understand that.
It's here because the complainant does not recall doing that, and I haven't been given proof that he did. And I'm not even sure that that's okay, but we didn't even get that far, Councillor.
Oh, okay, so that's, I was just curious because I believe our code talks about a sort of cutoff date for when, somebody were to sign up for an email newsletter in our existed in our role as a counselor, that we can't then take that and carry it over to the campaign. We have to keep those separate. You have to essentially start fresh. That's my understanding. Is that correct?
Correct. And complainant 2104 has made it very clear, just show the proof that that happened. Because the complainant does not recall doing that. And that may have satisfied the complainant enough. Yeah, but we just don't have any proof of that. Yeah.
Okay. Those are my questions. Thank you very much.
Thank you, Councillor Carmel.
Thank you, Mayor Iveson. So my questions today are all about, are made with reference to Mayor Iveson's preamble, in which she stated that our role here is to ensure that the process was reasonable in relation to the severity of the breach, and reasonable generally, I would say. So I guess my first question is, we have a situation where emails were inappropriately sent, either by confusion of database entries or confusion of email addresses or the source of those addresses. If those addresses were removed from a database, or if an apology was issued, or if amends were made directly to the complainant, would that satisfy the complaint?
Well, Councillor Cartmel, I can't speculate on what may be, but there was a separate one that was resolved that way, that Councillor Nicol took away and resolved. These complainants have not been satisfied with Councillor Nicol's response and have asked to proceed. And I also, I want to make it clear that I appreciate that this is all new to council. And if we could have sorted through this, I don't think we would be here. Rather, I was given responses that were unresponsive and frankly irrelevant. So yeah, I can't speculate on what may have been, but I would have hoped that we could have sorted out this in an informal way. Most of council would know that I've had a number of complaints over the years that we've been able to sort out and satisfy the complainant that let the councillor resolve this informally is the best way I can say it.
Well, I understood you to say that if Councillor Nicol had provided adequate response, we would not be here. So I guess my question is the breach sending an email inappropriately, or is the breach that Councillor Nicol didn't respond to your inquiries adequately?
If Councillor Nicol had responded, we may not be here, right? If the response satisfied me that the code had not been breached, we may not be here. If the complainants were content with the response, we may not be here. There are two things that are problematic. One, I have to decide whether there's a breach. I have to look at the evidence before me. The only evidence I have is the evidence brought by the complainants, not by Councillor Nicol. That's one problem. The second problem is Councillor Nicol is the only one that could have provided that information and cooperated in the investigation. I could do nothing else. So there's a failure to cooperate, and I have to conclude on a balance of probabilities that there's a breach of the code based on the complainant's information.
In your closing statements towards the end of your report, you stated that the role here is to maintain a fair process, and yet already we've had discussions around uninvestigated and unreported complaints that are in the hopper. Is there any apprehension that commentary biases this conversation? That we're talking about reports that either have not had a complete investigation or that complete investigation has not been presented to council?
So Councillor Cam Ashmore here. I don't think we should be getting into the uninvestigated complaints. There's been reference to them. There's no information about them. It would be inappropriate for council to decide on a sanction based on something that hasn't been investigated, hasn't been decided upon. I don't think you can assume one way or the other whether those other complaints are in fact a violation or not a violation. they're simply irrelevant to this entire process.
Well, I'm wondering about the relevance in that they were presented as information in the Integrity Commissioner's report to us. And with respect to ensuring that the process was fair, I have an apprehension that unsubstantiated investigations are being cross-referenced into this discussion.
Yeah, I think it's fair, Councillor, to have the Integrity Commissioner comment on whether or not that influenced her in her investigative process. I think that's a fair question.
Okay, thank you. Then I would phrase it that way. Thank you, Mr. Ashmore.
And fair point, Councillor Cartmel. When responding to these complaints, Councillor Nichol references the October issues and brings in these other issues. And I'm not influenced by those other ones. I'm just saying that from an intentionality point of view, when we're thinking about sanction, I'm concerned that Councillor Nichol knew back to October that these concerns had been raised. And absolutely, in the response, there are other things raised by Councillor Nichol about things that are not before council, and I completely agree we shouldn't be considering those. What I'm saying to council is this was an ongoing issue that I was monitoring to show that there was balance. This wasn't a one-off issue. There were ways that we could have resolved this, and I've been asked that question and I've answered it. The concern I have is that this is the public bringing forward these types of concerns, and I believe they need to be answered. I don't believe council should be persuaded in any way by any complaints that are not before council, other than the fact that Councillor Nichol, in response to these complaints, said that he'd already answered all of this back in October and references back to the uninvestigated complaint. And I referenced that in my report, then asked him if he wanted to add any more to it.
My time's up. Thank you.
Councillor Henderson?
Yeah, please somebody jump in if I'm out of line in the question I'm going to do, because I'm not entirely sure. But it strikes me, just to get a feel for the import of this, that there are also privacy issues here in terms of those emails. I know, for instance, that if we get an email about something, we're not even allowed to share it with the police commission, for instance, outside of the city, without having the permission of the person who sent us their email. And that has to do with privacy laws. And it seems to me that this is getting into that kind of territory. Just so we it may seem inconsequential in some ways, but it does seem to me there's other implications to this. And I'm wondering if somebody could speak to that piece of the puzzle, just so that I understand that it's around severity, I guess. And I think we have an onus not to be sharing emails that are sent to us outside of the city when they're sent to us on city business. And this seems to me that this is essentially one of those cases. Am I missing something here?
Councillor Henderson, there were concerns raised about privacy. That's outside of my jurisdiction.
Understood. Yeah, that's why I wasn't sure it was appropriate to ask. Yeah, understood. Yeah.
Outside of my jurisdiction.
Okay, thanks.
Councillor Banga? I think I might need a motion for a second round of questions for Councillor Banga.
So moved.
Thank you, Councillor Knack.
Second.
Seconded by Councillor Zadek. I'll just seek unanimous consent. Any objections to another round of questions? Not hearing any. Go ahead, Councillor Banga.
Thank you. Ms. Paital, from what you were discussing, that there were more complaints than the ones that were substantiated. And then, please correct me if I somehow misinterpreted them. And some of those complaints that were not, I guess, substantiated, they were resolved by who though?
Counselor, I'm just going to step in. Again, I'm going to remind council that it would be inappropriate to base any decision-making today off of other complaints that are not part of this particular investigation. So knowing what happened to those other complaints is really irrelevant to this process, so it's better simply not to ask at this time.
What's
Okay.
before us is the 4 complaints that have been investigated.
Okay, so I don't know if once Ms. Pytel, once your office receives a complaint, do you instruct a particular counselor who the complaint is against to not contact the complainants?
Unless there was something within the complaint that would warrant that instruction, I do not instruct counselors not to contact the complainant. But the process is then taken over by me. So typically no counselor is asked to do that. There is concern that by some complainants that we have provisions in the code about not retaliating, and some people may take that as retaliatory conduct. But I'm happy to, and I have many times offered up to complainants an informal resolution if possible, and suggested that could be done, counselor to constituent or complainant if they so choose. No, I don't specifically say do not contact the complainant.
Okay.
I don't prevent the counselor from doing that either.
So were any efforts in some kind of informal resolution for the substantiated complaints? Was it explored or offered?
What I offered to the complainants is the council, they chose to proceed with the complaints is the best way to say it. And they don't, you have to have an agreement from both sides to proceed informally. They chose to proceed. I offered them Councillor Nichols' response, and they did not accept it and asked to proceed with the complaint. We did not specifically get into informal discussions because they were clear they wanted to proceed.
Okay, not that I'm presupposing the outcome. So, I don't know if you would be able to say that or not, but was Councillor Nicol amendable to those some kind of alternative resolution? If
I don't know if he was amenable to some alternative resolution because, as I said, Councillor Banga, it takes 2 to tango, and you have to have both sides agreeing to an alternative resolution.
okay,
These complainants wanted to proceed with their complaints repeatedly. I kept going back to them with Councillor Nichols' response, and they kept saying, no, we want to proceed.
thank you.
Thank you. Councillor Zadig?
Thank you very much. So we heard that if Councillor Nicol provided you with more information, there's the possibility that we would not be here. So we're going off of primarily the information from the complainants. And I was just wondering in the process, if the complainants swear an oath or some type of affirmation of truth, given that this is a quasi-legal process, just wondering if what's in place just to I don't want to say challenge, but to just get the complainants, just for you to ensure that they're coming at this in good faith.
Well, there's a difference between good faith and evidence. And so what the complainants gave me who had that information, they sent me the emails where they had reached out to the counselor in his official capacity. They went back and reviewed their records and responded to Councillor Nichols' response saying that they had connected with him in his campaign. And I have not asked, and I've never asked, as long as I've been the commissioner, anybody to swear an oath. I've simply gone back to Councillor Nicol and not asked him as well to swear an oath that he did this, have just said, give me the evidence. So I was given evidence to support, in some of these cases, the contact that was made, but I have no way of proving what Councillor Nicol did without it coming to Councillor coming from him. So they've repeatedly said this. I haven't asked them to swear the oath that it's true, nor have I asked for an oath on either side. There is an ability for me to do that if I so choose. I did not ask for that in this case, Councillor Zadek.
Okay, thank you. That helps. No more questions.
Councillor Cartmel, if you could take the chair.
I have the chair.
Thank you. So just to loop back, Ms. Pytel, to earlier comments, you suggested you had found no evidence of bad faith on the part of the complainants, and since their motives or veracity has just been potentially imputed, just to verify, in your process, you would disclose the names of the complainants to the respondent councillor, yes?
Yes, and their email addresses that I asked him to search, yeah.
As part of the attempt to determine whether there was some other legitimate reason that those emails were obtained.
Absolutely. There would be no way for Councillor Nicol to respond to these allegations without knowing who the complainants are. But I was given no evidence that these were brought in bad faith. Otherwise, as I said earlier, I would have pursued that.
And if there was some basis on the respondent councillor's part to believe that these were brought forward in bad faith based on prior conflict, that would be, you provide every opportunity for the respondent councillor to bring that as mitigation or context. That's part of your process, is to test for that, yes?
I asked the councillor to elaborate, but there is no information on that. And council, bear in mind that there is a right to bring these complaints under the code. And so for me to find bad faith, there needs to be something substantive, because it's there as a right to everybody on council and as the general public to raise these questions.
And principles of administrative law and natural justice afford every opportunity for the respondent to raise and substantiate those objections, and that, other than in general terms, no substantiation was provided as to any substance of bad faith.
Nothing was provided, and I can say, even without the councillor, not in this situation, but any situation, if something came in from the complainant or through my investigation, which had me question the good faith aspect of the investigation, I would pursue that. But there was nothing. It's not for me to go out and investigate the complainants, but if something was given to me either by the complainant or through the investigation or from the respondent, then I would investigate that, or I would take that into consideration. There was nothing here.
And have you seen any evidence that there is any connection or association between these four complaints, or are they distinct complaints from distinct individuals acting individually? I mean, we don't know, but have you seen any evidence of conspiracy, I suppose?
I have no evidence of that, but a group of people could decide to do that, and that doesn't necessarily mean that they individually can't do it, but I've not seen any evidence of that.
Okay, so as far as we know, 4 citizens filed distinct complaints about code violations that, to the best of your ability to investigate and with every opportunity to respond, you've upheld.
Correct.
Okay. Thank you. I'll take the chair back.
Return the chair.
Councillor McKean.
Thank you very much. Ms. Pytel, you've recommended a letter of reprimand. Is that the sort of the lowest sanction we have on the books in the code?
Yes, if there's going to be, there can be no sanction, or the next level up is a letter of reprimand. Yes, correct.
So, and tell me, from, I guess, the perspective of natural justice, do you see this hanging on Councillor Nichols' record, or is it more just symbolic? The code, in your opinion, was violated, and that therefore there must be some sort of recognition from council, and this is the lowest or the least impactful sanction that we can bring to recognize a code violation.
Correct. So I put in my report the factors that weighed into it. It's related to an election. There's a previous record, the failure to cooperate, the need to maintain confidence in the code and the adherence to the code, and the intentionality that I'm concerned about if this is happening, that this is, yeah. So those are the factors, and it's progressive. So there's either no sanction, which is, this happens all the time. People, it's similar to a court proceeding where somebody can be found to have violated something, and the judge says, okay, but no sentence. So the very lowest is the letter of reprimand, in my view, and that's how the code is written.
In answering Councillor Banga, who was talking, I think he might have used terms like alternative measures or processes. So when I first read this, I thought, man, this could maybe have happened to my office, where I make a mistake, one of my staff or something makes a mistake. And what I would then do is reach out to the constituents, assure them that their name was going to come off the campaign material or the campaign list, and apologize to them. And I just wanted to just ask this one more time. If Councillor Nicol had approached resolution in that way, would we be here?
Again, I shouldn't speculate, but I encourage that all the time, and an apology would, and a resolution of this would cause the complaint probably to be withdrawn, and there's nothing to proceed with. Yeah.
The reason you have difficulty answering that is because the complainant could say that wasn't enough, and you wouldn't necessarily be able to pull your investigation then.
Under the bylaw, I'm obliged to investigate, and if it's within jurisdiction. It can be resolved informally, but as I say, both sides have to be satisfied with that outcome and agree to it. And so, yes, Councillor Nicol could have pursued that. And let's talk about sanction. Had there been, even if this went forward for some reason, but there was an apology and an accountability, this is why we met with council, because we were worried that something like this could happen, but there's not been any of that. And so I'm left with making a sanction recommendation based on the reaction to these complaints, which was, as you've seen, right?
Right. Yeah, thanks for confirming that for me. Appreciate it.
Thank you. Councillor Essinger?
Thank you very much. And I guess my question is, we have a code of conduct that we've agreed to, and it also allows the public, if they feel we have breached that, a measure of protection, and they can make the complaint, right?
Correct.
And you take every complaint seriously, and you work as much as possible to resolve those through alternate measures, some sort of resolution, is what I've heard.
Yes, I take every complaint seriously. I have to decide first if even they're in jurisdiction, and I can dismiss them out of hand. And yeah, and the parties can propose resolution as well, Councillor Eslinger. Yeah.
But even though this one we're hearing today, you've had others that you've dealt with and either dismissed or had alternate measures resolve them, correct?
So again, from the inception of the code to today, I've absolutely had informal resolutions of concerns that have been brought forward by members of the public, just generically speaking. Absolutely.
But these ones have not been resolved. This is what, and you consider it a serious enough breach to recommend sanctions.
Correct.
All right, thank you very much.
Thank you. Councillor Katarina?
Thank you, Mr. Mayor, and thank you, Ms. Patel, for the comments in the report. So on the severity of this, my interest is to see, so out of the four complaints that we're dealing with today, can you quantify the harm that was inflicted on the complainants, what the harm was to them? Because my understanding of this report is that an email went out, whether it should have or shouldn't have, or how it got there, but it did not force anyone to either contribute, take a sign. The option there was to ignore the email from Councillor Nicol. So what was the actual harm, if you gleaned that from the complainants, that they suffered in receiving this correspondence?
So the consistent message from the complainants, Councillor Katarina, was they want to be able to interact with their counselor without receiving this type of communication. And that has been consistent from the beginning to today, that they want to be able to have that without receiving this type of solicitation or email. And that was the principle that they've brought this forward on.
Okay, so that tells me there was no actual harm per se, but is there, or I don't even know if this is in our jurisdiction, but isn't there an opt-out or do not send me information, that sort of thing, that's actually in law? That people don't, if they don't want to be solicited for any particular reason, companies have to provide that option. Now, I don't know whether we do or not with this code of conduct. I don't recall ever seeing that, but I guess, people receiving this do not have to respond or do anything about it. So again, the severity of this and then the recommendation for a reprimand or a letter of reprimand, at this point right now, unless I hear something different, I don't think it rises to that level, because I don't believe there was any harm done, because people have the option not to move forward with a request or.
Do you have a question, Councillor? It sounds like you're speaking to it, so.
No, sorry, Mr. Mayor. It just, the question is that, the severity of this, I don't see it rising to this occasion. Now, Ms. Patel, if you can rationalize to me why this rises to that level, given what I've stated about the harm that is done or not done.
And so this is what's been communicated to me, Councillor Katarina, by the complainants. There's a concern that the councillor will use for his advantage his office in the campaign. There's a concern that they want to be able to contact the councillor without getting these sorts of communications. There's a concern that if they opt out, they may opt out from hearing information that they do want to hear. There's a concern that if they opt out, they may develop a negative relationship with the councillor who is their councillor. So all of those concerns have been expressed to me, Councillor Katarina, but the biggest one is the one about you have the advantage of being a councillor, and with that you get certain information, and it ought not to be used in a campaign in a way that the thing that was said to me by the complainant was, and the part of that goes to sanction is maintaining the integrity of the process and the public's view of the integrity of how the code is being administered, and the code covers election activity. And so all of those principles and concerns have been raised to me. In terms of the severity, I just have an obligation to say that if there is a record and if there is a violation, then I have to say something. But it's really, absolutely not my decision and whatsoever. And it's irrelevant to me what sanction council decides to make, if any.
Thank you, Ms. Patel. Thank you.
Councillor Henderson?
Well, just to follow up a little bit on this question of harm, because I'm curious about something, and you may not be able to answer this one either, but it strikes me that there is potential harm to people outside of the complainants on this one, which I think is part of our intent in putting this into the code to begin with, that has to do with incumbent advantage and not taking, and so that, is that something we should be taking into consideration, that part of the harm here would theoretically go to other candidates who do not have access to this information because it's not public. So I'm curious about that. I'm wondering if there are harms that go beyond the individual complainants here that we should be keeping in mind.
Well, Councillor Henderson, I assume that the principle behind this, and it's in the code, the principle is so that doesn't happen, that there isn't an unfair advantage to some degree by virtue of being in office. So you get this because, one of the complainants was worried about crosswalks and other incumbents or other candidates wouldn't be able to have that email address if somebody hadn't reached out and raised a concern about a crosswalk. And so that has been raised by some of the complainants, the fairness of the election across the board. And I assume that is the principle behind this code provision.
Yeah, and I guess so in that sense, I'm just thinking this through in my mind. In that sense, there is harm that would go to others beyond the complainants, theoretically, that is part of this. Is that a fair characterization or not, or is it irrelevant?
Well, theoretically, yes. And so when you look at the principle that's involved and why it's there, and again, it's council's code, I assume that there could be others that are concerned about it. This is the harm, if you want to call it that the complainants have raised. Recall that my job is just to say if it's a violation or not.
Fair enough.
But that is definitely a concern that was raised by the complainants, some of them. Yeah.
Great, thank you very much.
Yep.
Thank you. If there are no further questions, I take it, Mr. Dennis, you'll be speaking on behalf of Councillor Nicol?
Yes, Your Worship.
Okay.
I have submissions on both issues. I can address them individually or omnibus if it would be your pleasure either way.
Individually.
Thank you, sir.
Yeah, we have to keep them distinct for a number of reasons. So if you can speak, and you have up to 10 minutes, let us know if you need more time with respect to the first item in 6.6 before us here.
And thank you, Your Worship, for the opportunity to address you, City Councilors, Integrity Commissioner Pytel. For the record, my name is Jonathan Dennis, it's spelled D-E-N-I-S. I'm a lawyer at Guardian Law Group in Calgary. My submissions relating to the first issue are quite brief. We have previously submitted our written response, which I understand you have received on June 8th, 2021, and we rely upon this submission, but we also wish to make some oral submissions today. As I'm sure you all remember, this is not the first time that Councillor Nicol has been investigated by the current Integrity Commissioner, not the first time this Integrity Commissioner has found Councillor Nicol deserving of sanction, and I'm sure as well, I need not to remind you the last time that Councillor Nicol was before you on September 2nd of 2020, you voted that Councillor Nicol's conduct was found not to be deserving of sanctions. The first issue that we've dealt with today deals with 4 email addresses provided to him in his capacity as councillor as it relates to the Merrill campaign. I reiterate that we're dealing with 4 email addresses here, and I question what possible advantage anyone seeking any type of office could obtain by receiving access to 4 email addresses. I ask you to respectfully reject sanctioning Councillor Nicol in this respect, and importantly, these reviews against him have cost over $100,000 of Edmonton taxpayers' money over, again, a few emails and a couple of social media posts, the latter of which I will address later. I refer you to pages 5 and 6 of our written submissions. I would respectfully submit that the onus is on the Integrity Commissioner to establish guilt. It is not the onus reverse on Councillor Nichol to prove innocence. Relating to the email complaints, none of these complaints with respect are valid and in any respect in the broadest sense. As previously stated by Councillor Nichol, all of these email addresses were collected during Councillor Nichol's past mayoral campaigns and on his campaign website through petitions. To contact Mike Nichol's city office, someone needs to use the Edmonton.ca page for Councillor Nichol. When you go to Councillor Nichol's election website and send him an email, of course, he's going to put you on a mailing list. That is politics. I'm going to repeat this again because I feel it's vital. Contacting Mike Nichol through MikeNichol.ca will put you on his email address list. You can easily unsubscribe by simply clicking the link once and bang, you're off the list. MikeNichol.ca is Councillor Nichol's personal campaign property. This process doesn't have jurisdiction over this, and the same also goes for any other councillor's personal websites. For example, Councillor Knack's Knack Mobile. It is his property. They both can do with it as they will. I do want to respond briefly to some of the comments that we've seen from members of Edmonton City Council today. I want to note that it's noteworthy that the Personal Information Protection Act, which is a provincial statute at a higher level of government, namely the province, exempts political activity from privacy regulation. And I refer you specifically to Section 4, Sub 3, Sub N as in November of this Act. And therefore, this body, in our view, lacks the legal authority to impose such sanctions of political activities, which again are exempt, and in further detail, that is in page 4 of our written submissions. The Integrity Commissioner indicated in her submissions today that Councillor Nichol would perhaps have a negative view of some of these constituents if they decided to opt out of the mailing. Respectfully, this is pure speculation, and there's no evidence to that effect at all. I also wish to respond to Councillor Henderson, who had indicated that there may have been other issues like this. Respectfully, this inquiry and any sanction, if any, resulting therefrom only deals with what is before the Integrity Commission, and that is these 4 emails. There is no evidence of any other complaints. There's no evidence of any other infractions, and respectfully, City Council can only consider the complaint that is before it today. I lastly wish to quote from Councillor Hamilton, who unfortunately wasn't able to attend. I quote from her correspondence of June 23rd of this year at 5:02 p.m. I would suggest that Council refrain from any sanction and leave the decision to the public in the forthcoming election. Council needs to turn its focus to the formidable agendas awaiting us between now and the end of the term, regardless of the quality of the discussion. This will prove to be a distraction. It is therefore our submission that the proper venue for assessing these issues is in the political process and not through this process. If people feel that these 4 email addresses are valid, they have every opportunity to choose a different candidate for mayor. Those are our submissions, and I do have submissions relating to the second item when that does arrive.
Thank you, Mr. Dennis. Questions for Mr. Dennis?
Not a question, Mr. Mayor, but I think a point of privilege or a point of order. I never suggested that those other 4 pieces, anything beyond the 4 that we're dealing with today, should be part of our discussion here today. So to be quoted as doing so disturbs me greatly.
Yeah, that's a point of privilege, and that's valid.
May I respond to that, sir?
If you wish to retract the statement.
No, I do not, sir, because I think it was a reasonable assertion that Councillor Henderson was going through, and he was suggesting that that there could have been other issues. And my point is simply that it is simply before the committee about 4 email addresses, and we cannot consider anything other than that. I believe that was a reasonable comment, just in respect to Councillor Henderson's comments.
Well, and I think Councillor Henderson would agree with you and said that what's before us is the 4 emails. So I'll uphold his point of privilege. I've got one question. Oh, actually, we've got a number of folks on the board. I'll just ask mine right now. Councillor Cartmel, if you could take the chair.
I have the chair.
So you, Mr. Dennis, you mentioned the protection of privacy legislation. That's not before us. We're not the privacy commissioner of the province. We're not making a privacy determination. There were questions asked and answered of Ms. Pytel around that, but you've in your submission said that legislation exempts political activity from privacy. Is it your view then, or your client's view, that constituency correspondence is political activity?
I believe political activity can be defined very broadly, but also that there is a very narrow line between what would be political activity for a councillor or anybody who's sitting, and what would be considered as government activity. There's a very, very narrow line here, and I think respectfully, Your Worship, it sets a very, very dangerous precedent to be regulating what constitutes political activity or not.
But would you agree that the code is fairly clear, apart from what the privacy legislation says, which is not before us today, but would you agree that the code is fairly clear that correspondence and personal information collected in the conduct of official duties is separate from political duties?
I would agree with that, Your Worship, but at the same time, I would qualify that by responding that these email addresses came from something that cannot be argued is not political activity. It came from Councillor Nichols' past mayoral campaigns from the website, and therefore is beyond the jurisdiction of the Integrity Commission.
I don't even think I had an email address the last time Councillor Nichols ran for mayor. Sorry. So your suggestion is that folks who contacted him in the 90s when he was running previously would have provided those email addresses?
My suggestion, it's not a suggestion, but rather my submission to you, which is also in a written submission, sir, is that these email addresses did not come from people contacting him through the Edmonton.ca website. They came through past campaigns. For the record, I've had an email address since 1993.
Okay. Those are all my questions. I'll take the chair back.
Return the chair.
Councillor McKean?
Yeah, thanks. Mr. Dennis, you'll correct me if I'm wrong, but it seems to me the evidence before us today was there was no attempt by Councillor Nichols through informal processes to alleviate these people's concerns, take them off lists, maybe a quick apology or an explanation at least to show that they were in fact on Councillor Nichols' earlier, or on his, had reached out to his personal political website. Why none of us want to be here today. Why would your client not take those informal steps?
I would respectfully, thank you for the question, Councillor McKean. I would respectfully state that Councillor Nichols, and my view as well, is that this whole process is beyond its jurisdiction. This is reaching far too far, and Councillor Nichols had no obligation to go and respond as you respectfully suggest. These people simply could have unsubscribed, and we wouldn't be here today. I agree with you that we shouldn't be here today.
Fair enough. Thank you.
Councillor Banga?
Thank you. So, Mr. Dennis, if I am understanding correctly, your submission is that the burden of proof or onus is on the Integrity Commissioner to produce the evidence of harm, and also producing the evidence of whether that information was obtained and used for personal political, gains. Is that, have I summed up your your summation in this correctly?
Councillor Banga, thank you for your inquiry. That is correct. It is our submission. It is the onus is on the Integrity Commissioner to establish some sort of wrongdoing. I realize this is not a court, but the Constitution applies to any tribunal or other board in Canada, contrary to what what the Integrity Commissioner had indicated. And for any type of sanction or offense, the onus in this country is always on the party asserting the wrongdoing.
Okay, and you also did raise concerns about, emails, phone numbers, et cetera. People call us or send us emails all the time, and if we contact them, it is their choice to whether they want to stay on that list or not.
That is absolutely correct, and Councillor Nichols indicated that he would absolutely honor that. All I have to do is reply and say unsubscribe, and that's the end of the story. I would also again reiterate that the line between what constitutes government work and political work can often be very, very blurred, and I think it sets a very dangerous precedent to be trying to regulate this.
Thank you. That's all my questions.
Thank you, Councillor Paquette.
Thank you very much. Just to get to the heart of the matter again, based on the evidence, the Integrity Commissioner has found that there was indeed a breach based on the evidence. You've indicated that the emails were collected not through council communications, but through political activity. And we have a finding based on evidence. But now we're being asked to consider something that no evidence has been provided for. That is kind of makes the mind boggle. So I'm just curious if you'll be providing evidence of your claims.
So, Councillor, before Mr. Denny weighs in on that, I'm just going to walk council through this, because I think really what this is partly about is a finding by the Integrity Commissioner that includes a finding that says there's an implied obligation to cooperate within the Code of Conduct. The Code of Conduct does not specifically say one way or the other about the level of a councillor to cooperate with the Integrity Commissioner. It's simply silent on that. Ms. Pytel has indicated in her report she feels that there's an implied obligation to cooperate, and I think council will need to wrestle with whether or not the silence in the code should impact the severity of the penalty, or whether there shouldn't be a penalty because it is silent on that particular issue. What I'm hearing Mr. Denny essentially say is that that is a factor that should have been taken into account by the Integrity Commissioner in their investigation. This council right now has no ability to say there was no breach, just to be clear. But what it can do is say, well, there's some issues with the procedure that would lead us to decide something different in terms of the penalty. And I think that's kind of where you're along the lines right now. So if Mr. Denny is actually asking you to find that there was no breach, council doesn't have that ability right now. If Mr. Denny is asking you to find that there is something wrong with the way the Integrity Commissioner investigated this as it relates to the Code of Conduct or whatever, council can certainly take that into account in deciding upon the ultimate sanction or no sanction decision.
Okay, so I withdraw my question to Mr. Denny, because that makes sense. But just to clarify with you then, based on the presentation from Ms. Pytel, there has indeed been a breach. That's not in question based on the procedures that we have. And so at this point, we're just being asked to limit the severity of, to either write a letter of reprimand or not, and that's it.
Or any other possible penalty that council can come up with. Council can come up with whatever penalty it decides upon. or no penalty whatsoever.
Okay, but just to clarify, based on the code of conduct that all councilors voted on, there has indeed been a breach found by the Integrity Commission, regardless of anything else.
Correct, Councillor. And just to be clear, if there is since council only has the ability to deal with the penalty, there is a possibility that the procedures and or decision of Ms. Pytel goes directly to the courts on the breach aspect. So council isn't overturning or deciding upon whether there was a breach or no breach. If that was up for grabs after Ms. Pytel issues her decision, that can go directly to the courts.
Understood. Thank you very much for that.
Your worship, may I respond to one comment that?
I yield my time, actually.
Well, there was originally a question put to you.
Yeah, Mr. Mayor, if Mr. Denny wants to respond to anything that I said, I think that would be wise to allow that to take place.
Okay, go ahead.
I'll be very brief, Your Worship. The only thing I just wanted to, just two things. I'm not suggesting that the council overturn the finding of a breach. I'm suggesting that there ought to be no sanction. The other comment that Councillor Paquette had made, he suggested erroneously that we had not provided any evidence of alternatives as to how the email addresses would be obtained. I respectfully state again, the onus is not on us to disprove our innocence, but in any event, we have provided evidence. I refer you to page 3 of our written submission of June 8th. The first paragraph on the bottom under analysis, we did provide evidence in that respect.
So to privilege. I did not make a claim. I was simply repeating the information that we received from the Integrity Commission.
Understood. Councillor Henderson?
Yeah, I wanted to just to follow up a little bit, I think, in some ways on the last point, Mr. Dennis, because I think I heard you say, or one of your arguments was that because of the gray area between government activity and political activity, that this is not part of what we should be taking into consideration is that this is an area that we should not be regulating. And I'm puzzled by that argument because it is in the code. We've had a finding in the code that this is indeed something we should be regulating. So your argument seems to be questioning the code rather than questioning the severity of what we're doing here. And I just wanted to give you a chance to respond to that, because if this is a debate about going back and revisiting the code, that's an entirely different issue. But I'm puzzled as to how that is an argument about whether or not we should be following up on the fact that there sounds that there's a ruling here that there's been a breach of the code as it stands.
To respond to you, Councillor Henderson, thank you for your comments. First off, I'm not going to make a point of privilege as you did against me. I'm just going to respond to you because I did not say that. I'm talking about the principles of all of this and the broader scheme of our democracy. We obviously differ. I'll leave my comments at that.
But that seems to be questioning our code rather than what's happening right now with the breach of the code.
Which is, again, not what I did.
Okay, fine, thanks. Yep.
Any other questions for Mr. Dennis? Not seeing any. And we won't have an opportunity to ask direct questions to the respondent councillor.
Councillor Nicol was not able to attend today.
Gotcha. Is anyone willing to put the motion for the recommended sanction on the floor?
I'll move it, Mr. Mayor.
Thank you, Councillor Walters.
Second.
Seconded by Councillor McKean. Do you want to speak to it, Councillor Walters?
I can close.
Okay.
There's others.
Others wishing to speak to it?
Yeah, I'll jump in.
Councillor McKean, go ahead.
Yeah, I find this one kind of baffling, to be honest. And I think drawing hard lines between the work we do as city councilors with constituents and then over to our campaigns, I think those have to be hard lines. And I use the word baffling, and the reason I use that is I just think, you know, I thought if this had happened in our office, if I were running again for council, how I would handle this. And I would try to get to the bottom of it right away, and I would do whatever I could to make the complainants satisfied that, A, I'd made a mistake, or to show evidence that they'd in fact signed up onto my website. But even if that didn't satisfy, I would take it upon myself or my staff to remove them from that list. There's a certain combativeness or defiance in Councillor Nichols' way of dealing with these that I find it a little bit baffling. The integrity of our elections is critical. And I think we're being watched today. And this may seem like a small matter for emails, but there's a principle at play here of public service as an elected official versus candidacy to the election. And people watching us today will be other candidates, but also the public at large, about whether or not we're willing to uphold our code of conduct, which, if memory serves, the motion came from Councillor Nichols. Yes, there will be a letter of reprimand, which is the lowest sanction available to us, and is hardly a black mark on somebody's reputation for the rest of their political lives. But again, we're here to uphold the code of conduct. And I think the way we do that here is with a very minor sanction of a letter of reprimand. And I will be voting in that regard. Thank you.
Thank you. Councillor Cartmel.
Thank you. So again, I'm going to state that my comments and my concerns here are about the process and whether or not the process was reasonable. And I'm drawing upon my experience as the manager of investigations at APEGA for 2 years and my role in the discipline committee at APEGA for 10 years. There was a time at APEGA where such code of conduct or code of ethics concerns were brought to the investigative committee. The investigative committee would investigate, then make findings of fault or otherwise, and then make findings of discipline, and then receive any appeals. That system was changed about 20 years ago, and there is now a separation of investigation, discipline, and appeal. This is the systemic fault in our code of conduct, and I want to provide an analogy for that. Police investigate, judges judge, the appeal court sees appeals. One can imagine if you are, first of all, the subject of an investigation, that you have someone investigate you, then find you guilty, and then the next day start a next investigation about you. There is an apprehension of bias in that system, not with the individual doing the work, but with the system. Drawing upon that APEGA experience, one of the things that you can count on is being subject by a jury of your peers. There's a perspective that goes with that. And that perspective is being someone, in this case another engineer or geoscientist, was the action of the subject reasonable in the moment? So I put myself in that position of being a counselor subject to this process. I'm finding myself in this sort of a tribunal experience having made 4 database errors that could have been remedied by clicking on unsubscribe. Does that rise to a level of sanction? In a separated process, an investigator might find that there is indeed a breach, but a discipline panel might find that that breach does not result in a sanction. They are separate processes to remove that apprehension of bias. When I was at APEGA, we had a number of people that had repeated complaints against them. When they had repeated complaints against them, there were different investigative panels and different discipline panels that heard those individual complaints, again to remove that apprehension of bias. So in terms of database errors, were Councillor Nichols' actions regrettable? Were they correctable? For sure. Could he have acted differently? Perhaps. But does that give rise to a sanction hearing in this process? I don't believe it does, given I don't want to be in this position where if I make a couple of database errors, or during a campaign a couple of volunteers make a couple of database errors, that I find myself sanctioned and subject to this tribunal. We need to fix our system. We need to fix our code of conduct. That is not the fault of the current Integrity Commissioner. That is the fault of Council for creating this system. I want to comment on something else too. So this process needs to be seen to be fair. By an objective, dispassionate, third-party observer, does this seem fair? I've outlined the process, the investigative processes that I don't think would be seen to be fair because of that apprehension of bias. But these systems, these conduct questions, these tribunals are meant for when there's not a superior process. Again, when I was at APEGA, if there was a concern that was before a superior court, a criminal court, a civil court, the APEGA process was suspended until that superior process was complete. We are in the midst of a superior process. Now, our code of conduct puts in what has been termed a blackout period of 90 days, but that was before the province changed the rules around elections. Our election period started January 1st. We are in the midst of a superior process, which leads to an apprehension of bias that candidates in the upcoming election sitting at this table are using a council process to somehow undermine the efforts of another candidate in that process. That's not necessarily what is happening, but there's an apprehension that it might happen in this process. And we need to eliminate that apprehension. So to sanction on the basis of these processes, to sanction on the basis of the timing of this sanction hearing would be wrong. It would be an inappropriate sanction at an inappropriate time for the reasons I've stated. There's simply too many places in all of this, in this bundle of material that's been presented to us, where a fair, objective, dispassionate person would see that there is an apprehension, not a bias, but a potential of the apprehension of a bias. And for that reason, I cannot support a sanction.
Thank you. Councillor Banga?
Thank you. My thoughts are pretty close to Councillor Cartmell's. When I'm looking at and drawing my conclusion about whether we should be sanctioning this particular councillor or not, I am drawing it from my past police experience. I must declare that this is not a police investigation. This is a code of conduct investigation. So in the police investigations, again, when somebody makes a complaint, the police gets a name and number and whatnot, and then get a written statement from them, and then there is some kind of oath that they are sworn to, that this statement they are producing is the right statement. And then what police officer or any investigator does is they investigate. And in the investigation, we often hear, guided by the lawyers, that do not say anything. In my mind, if we are somehow even remotely connected to that spirit, counselors' combativeness, defiance, apparent defiance. I don't know if it's defiance or again somebody respond the way they think they would be responding, and that should not be an admission of guilt and or should be figuring out in the severity of I guess sanctions, whether there are sanctions, whether there are no sanctions. And agreeing with the previous speaker, of course, right now we are in the midst of all this. Again, before it was 90 days. Now, I mean, everybody declared on the, or most of the folks declared on January 1st or soon thereafter, whether they would be running again and again. So if we were to, somebody was to say that, oh yeah, he or she used my name or information from when I contacted him or her, this is, there's a pretty fine line. So basically what I'm trying to say is that any objective third party will consider this as a biased process, saying that we are intentionally trying to muddy somebody's name. I don't think we are here to do that. And we are here to make sure that we have the appropriate sanction, whether it's a reprimand or no sanction. Ms. Pytel, Integrity Commissioner, she did her investigations. I am not trying to say that those investigations were not complete. In what she presented, that the burden of proof was somehow on Councillor Nicol, and I don't believe that was I guess a procedural thing. And again, I don't know what's going to happen, but I think there's a problem in the system, so I will not support any sanction.
Thank you, Councillor Banga. Councillor Henderson?
Well, I just to follow up on, on what Councillor Bang is saying, I'm deeply uncomfortable that we have to be here doing this. I don't like doing it. It's a very hard thing to have to do. And maybe that goes back to Councillor Carmel's point as well. But we did create a code. We did create a code of conduct. We've heard that one of our members is in breach of that code. And what troubles me most about where we're at right now, and unfortunately we did not have a chance to talk to Councillor Nicol, so I can only guess, but from the tenor of the response of the representative he did send to us, and to the tenor of the response of what we've read in his answers, is I don't necessarily see there's a recognition from Councillor Nicol that what he did was wrong. And that troubles me deeply. That there's actually a question here about whether or not the code is right or not. And this is a code we all signed on to. And I do think there is import in this code. I think there's a whole bunch of issues, and some of them I think are part of what the complainants brought forward. But I think having a fair election and not giving incumbent advantage was one of the major reasons why we felt it was important to put this in to begin with. And that is fundamental. And the fact that I'm not hearing recognition from Councillor Nicol that that is fundamental troubles me. And I'd love it if he'd been here to going, I get this, I understand why this is important, and we'll do everything we can not to make errors in the future, but I haven't heard that. And I worry a little bit by shrugging and saying, not responding at all, we are implicitly saying we don't think it's particularly important either. And I think it is important. I think there's something really fundamental to our process here that needs to be recognized. And I would be absolutely comfortable if Councillor Nicoll had come before us and recognized that. But that hasn't happened here today. And I think that's putting me in a really uncomfortable position, understanding the timing of this is deeply problematic, understanding the discomfort that all of us have, that I'm really worried by not sanctioning now, where essentially either condoning and suggesting that our code was incorrect to begin with, or saying that this part of the code doesn't matter very much. And that troubles me deeply. Maybe that is a debate we should have, but this is not the place to have it. Based on that, I'm really feeling backed into a corner here that I have no choice but to vote for some form of sanction, because my feeling is anything else is essentially condoning that we don't think this matters very much.
Thank you. Councillor Knack.
Thank you, Mr. Mayor. I'm struggling a little bit with the notion, with some of the comments around the process. And, you know, as was noted at the beginning, we're not here to investigate. That process has been completed. We're here today as part of a sanction process and to determine the appropriate sanction, if any, for what is a confirmed violation of the Code of Conduct that we all agreed to. And appreciating that some of the provincial rules changed around the ability to officially register as a candidate, I don't think for me is a valid one, because I can think back to many elections where candidates were already up. They might have not been officially declared as a candidate, but who were doing the work as far back as January in many cases. And if we feel that that is not, if we are concerned about using the Code of Conduct when somebody can officially register, that makes me ask the question if that means that for almost a full year, we aren't going to hold ourselves accountable for our actions. That to me is a very troubling message to send members of our public. That for almost a quarter of our term, there will not be consequences for the decisions that we make. Similar to Councillor Henderson, I very much would have preferred a different discussion today. We all make mistakes. Nobody here has not made a mistake. The question is what we do when we make that mistake and when we are called out on that mistake. I think had there been a different discussion, as Councillor Henderson mentioned, if there was a conversation today around, you know what, I made a mistake, this shouldn't have happened, you know, I wanted to make sure I followed the rules. I don't know if I would have wanted to approve a sanction, because goodness knows we're all going to occasionally make an error. But again, it's taking accountability for our actions. And that's why I think what we have heard today, completed investigation that was presented to us, was that there has been a breach of something we all agreed to. That Code of Conduct was created using best practices from other jurisdictions as best as possible. We spent time reviewing it. We got advice. I'm sure it's not perfect. I'm sure it can continue to use refinements and enhancements. But until we finish that work, we are still operating with our existing code. So that is why, for me, I wish I didn't have to support this today. But there was a violation, and we need to be accountable for our violations, for our actions. So I'll support this, and I think if we want to have a conversation, which, as was noted at the beginning of the process by the chair, we should have a conversation about the actual bylaw itself. But that is not what is before us today. What is before us today is a bylaw that we all unanimously agreed on. And I think we should be making our decision today based off bylaw that council all agree to. Thank you.
Thank you. Councillor Cartmel, if you could take the chair.
I have the chair.
So accountability is awkward. No doubt. And that's why you need clear rules and a fair process to try to make it as straightforward as possible. But there's no way around the fact that it is awkward that we're in this circumstance. But I'd rather there be clear rules and a fair process to deal with circumstances like this than not, which is why I voted for the code of conduct as it was written and as it applies. And the question of whether it should be different or the timeline should be different or the processes should be different is not before us today. The code, in fact, is the context here. And there is an electoral context, there is a political context. It's inescapable, but it is also the point of that particular section of the code, which is that we are held to a high standard and have decided to hold ourselves in adopting the code to a high standard. And we have decided that there is an especially high standard with respect to what to do with the personal information of our constituents vis-a-vis the electoral process and the political process. And the code is very clear that that information cannot be used for electoral advantage, period. 4 citizens have come forward, and I think speculating as to their motives is deeply offensive to our citizens when they have brought forward concerns about this black and white issue in the code. And the additional context beyond the black letter of the code is that there have been education sessions, clarification sessions, memos of interpretation, an abundance of information provided to interpret and make crystal clear what the expectation in our code of conduct is, which is that we will not use the personal information of constituents collected in the course of our governing duties as their constituency representatives for electoral advantage. And what's more, the Integrity Commissioner has reminded us today that that concern was raised with the respondent councillor back in October based on a previous complaint that wasn't pursued, but it is germane because the issue itself was raised with the councillor previously. And that was prior to the beginning of overt campaigning, prior to any sensible notion of when the blackout period should apply, which again is not even a question that's before us today. Most troubling to me is that the argument raised by Mr. Dennis that the line between government work and political work can get blurred is deeply problematic, because this council has said it should not. But it can get blurry if you let it, if you let the code slide. So I think we have to take a stand based on the feedback of 4 citizens who raised a complaint about a violation of the code. And no compelling evidence has been given that there was a good faith error here or a database error. That is supposition. These constituents have said, to the best of their knowledge, and they would know best, they have only interacted with the councillor on constituency matters. No credible evidence has been brought forward to the contrary on that. So to disbelieve those 4 citizens, to get out of the awkwardness of administering accountability for a black and white election neutrality section of the code, is deeply problematic in my view. If some candidates, if any candidate in this election or any other is using email addresses obtained at City Hall in the course of their constituency representative duties for campaign purposes, that does confer an incumbent an electoral advantage, which is why the code is written as it is. So I think we have to listen to these citizens, not question their motives, take their evidence, trust that there has been a thorough investigation, and conclude what we must from the fact that there's been nothing but combative and defensive response from the respondent counselor. So I'll be upholding the sanction in my vote. Take the chair back.
Retain the chair.
Thank you. Councillor Caterina.
Thank you, Mr. Mayor. And so on this, the struggle for me is still on the severity. If this was something that I believed was intentionally done for that purpose that is being stated, 4 out of, as we all know, the hundreds and sometimes thousands of emails that correspondents received through our office, and 4 is what has come forward out of that number. That goes to the severity of this and the intent of this. I don't think that it's been established that the intent was to misrepresent or misuse of city assets or property in that. So, but there's something really, really troubling to me right now, and this is on the fairness process. You know, this is quasi-judicial, but we are not here as counselors, but that code that we keep an open mind, and Mr. Ashmore, you've told me that many, many times at CSLAC, that we do not form an opinion prior to hearing all the evidence from both sides of the argument. So the fairness part of this, I don't think has been upheld to by the proceedings this morning. The biases are extremely obvious, and I can explain that, Mr. Mayor, either in private, if you like, or I can do it in public. But it is really telling of how this process has gone this morning. And I know I'm speaking to it, so I'm going to make the call myself. That I am going to make this public right now. So at 9:45 this morning, when we were just setting up the rules and everything else, I received correspondence from the mover of this motion through message, and I want to quote, and then you decide, or everyone decides whether there's a bias or not. And here's the quote. I'm so sick and tired of this motherfucker. He should be hospitalized.
Councillor Caterina, I think if you're going to read from the correspondence, maybe just, and I'm not sure that this should be happening, but.
That's why I said that I could go in private, but there was no response. But this goes to the fairness of this process, that there is the mover of this motion to sanction. That's his mindset coming into this hearing this morning. And if you think that that's okay, that's for individuals to rationalize in their own mind. But this certainly is not okay in the rationalization in my mind. This is nowhere near that. I don't believe that a letter of reprimand has reached that level of the seriousness of this. But to have this
Mr. Mayor.
As a motivation for sanctions.
Sorry, I'm going to stop you for a second, Councillor Caterina. Mr. Ashmore would like to provide some advice.
Okay, that's fine. I did give the option to go in private.
I'm just going to ask you to hold for a second. I heard you. Just pause for a second, please, Councillor Caterina. Mr. Ashmore?
Yeah, Mr. Mayor, Councillor, I think your point has been made. It's a good point. I don't think you need to go any further on that point at this point. But I think it's pretty obvious that there was an issue, and you've raised that issue, and that is something I think the council is going to have to deal with as well.
So anyway, with that, I will be voting no to any sanctions. I don't believe it rises to that level with the seriousness of this. All 4 of the complainants could have opted out and not responded, not received any further communications, not donated, not taken a lawn sign, not have done absolutely nothing, and without formally filing a complaint about this. So I will be voting no to the sanctions, Mr. Mayor.
Next is Councillor Essinger.
Thank you very much. And I don't know the motivation of the people who made the complaints. But I do understand they made a complaint. And I understand that it was investigated. And it was determined that there was a breach. A breach of the code of conduct we all agreed to. And that the suggestion whether we sanction or not was not up to the integrity commissioner, it's up to us. For me, I am concerned that if we do not uphold and do a sanction because someone breached our own code that we agreed to, what is the point of having a code? It's useless. Why would our public ever think they can complain or make a request an investigation if we don't even take them seriously? I take them seriously. They felt it was important enough to make a complaint that was investigated, and it was determined there was a breach. I, like you, are very uncomfortable having to do this. And I'd rather we had a different conversation. I would have rather that the counselor had worked with the complaints and come to a resolution. That just did not happen. And I can't speak to motive on either side. I am going to support this sanction because I take our code seriously. I've heard several people this morning talk about the process. This isn't the first time we've been here. And since the last one, no one said we need to change our process. We had a chance to change our code, to change the process. Nobody said it's wrong until now. And those who felt it was wrong last time didn't determine it changed. So that's on us if we didn't change it. But at this point, this is the process we have. There is a breach, and I will support the sanction. Thank you.
Thank you, Councillor Essinger. Anybody else before I go to Councillor Walters to close? Councillor Walters?
Thank you, Mr. Mayor. So I will apologize for using unparliamentary language in a text message to a colleague, reflecting enormous frustration and legitimate anger in my soul at the moment about the fact that we continue to find ourselves in this circumstance where one member of our council, in my opinion, puts us in this position and puts himself in this position because he feels that it benefits him. I'm not here to quibble about the process. We quibbled about it for months when we debated, designed, and passed and approved the code originally. Keep reminding, and it's been mentioned again, that it was Councillor Nicol who in fact was the mover of the motion that put the code on the floor to be voted on by council in its final form. So, of all the things that this council has to do to serve our citizens, particularly in a time of economic uncertainty and recovering from a pandemic, to be here again, going through what our integrity commissioner has found to be clear violations based on the process that we do have, which is very clear. I don't see the side doors here that many other councillors see. The anger I feel about having my time wasted, my constituents' time wasted, the money that's being wasted on this process, when the violations are as plain as day, and the codes has accountability for those violations, which are also plain as day, and it's our job to uphold the code. That's why we're here in this hearing. So I'll repeat my regret for the text I sent to Councillor Katarina in enormous frustration for our morning being wasted, and time being stolen, from our work that we should be doing to serve our city and our constituents in far more productive ways, than how this time has been spent today. I just feel that there's simple information that could have been, we've talked about this morning, good questions from my colleagues, simple information that could have been provided, simple conversations could have been had with the Integrity Commissioner to avoid this hearing from taking place in the first place. And I think, maybe my sense is that there's good reason that the particular council wants this to happen, because this is what infuriates me, is that there's political benefit, and I'm not speaking for anyone else, but I'm ensnared in it. So I have every right as a councillor on this body to be frustrated and upset about that. This could have been avoided. The repeated pattern of behavior suggests, and I think this is well documented in multiple Integrity Commission reports now, suggests that the violations are clear, and when they repeat themselves, the pattern almost becomes obvious that there's a degree of intentionality to it. So my final apology to Councillor Katarina, but I was here. I listened to the hearing. I read the reports. So my vote is not based on bias. It's based on the facts in front of us. My text and my raised voice today is clearly reflective of being upset by this waste of time and waste of money. But my vote, my moving to the vote motion and the vote is based on the facts. We have an agreed upon code of conduct. We have an independent integrity commissioner that oversees that code and rules on that code when complaints are made. Facts are clear. So this is a small, probably fairly inconsequential bit of accountability for Councillor Nicol to receive a reprimand from his peers for treating us badly, wasting our time and our citizens' money. Thank you.
Thank you. Please vote, and this is a special resolution which is not based on attendance, it's based on the size of the assembly, so it requires 9 to pass.
No.
No for me as well, Madam Clerk.
Thank you, Councillor Banga. Thank you, Councillor Katarina. We are still waiting for 3 votes to come in. Councillor Henderson, are you able to vote electronically? We've got your vote. Councillor Paquette.
Yes.
Thank you, Councillor Paquette, and Councillor Walters.
I'm a yes.
Thank you. We have all the votes, Mr. Mayor.
Display the vote. And that has failed 7-4. All right. It being 11:30 and there being another matter at least as time-worthy, let's say, there's no way we'll be able to do justice to that item in half an hour, and starting it and not finishing it, I think, would not be fair to all parties concerned. Therefore, in consultation with Mr. Dennis and the clerks, the suggestion is that the next available time in council's calendar, and that works for the respondent councillor's legal counsel, is the afternoon of July 5th. So we can appropriate that time from the council meeting. So I need a motion to postpone item 6.7 to Would it be 1:30 on
I'm
the
just looking
5th?
at that. If you could make it time specific at 1:30, and just for clarity, the July 5th and 7th council meeting, it's a two-day meeting, both from 9:30 to 5:30.
So moved.
Thank you, Councillor Cartmel.
Second.
Seconded by Councillor Banga. Any debate on postponement? Not seeing any, please vote.
Councillor Katarina?
Yes, Madam Clerk.
Thank you, and Councillor Zadek?
Yes.
Thank you. We have all the votes.
Display the vote. That's carried. Okay, are there any notices of motion at the conclusion of this meeting?
I have a notice of motion, Mr. Mayor.
Go ahead, Councillor Essinger.
I will move at the next city council meeting that administration engage, number one, engage with key stakeholders to define the mandate, functions, and authorities and membership criteria for a child-friendly advisory committee and return with a bylaw and terms of reference to establish a child-friendly advisory committee. Number two, provide information on a funding strategy for the ongoing support of a child-friendly advisory committee. Due date, fourth quarter 2021.
Thank you. Notice is received. Any other notices of motion today?
Mr. Mayor, I have a notice of motion intended for tomorrow. I can make it today, but tomorrow is fine too.
It's up to you. There are no notices at the special meeting tomorrow. So if you have a notice that needs to be made this week, today would be the day.
Okay, I'll just, my apologies, give me 5 seconds to pull it up.
I've got others who have notices, so I can come back to you, Councillor
okay,
Paquette, while
great.
you pull it up. Councillor Cartmel?
Fantastic.
Thank you, Mayor Iveson. So at the July 5th City Council meeting, I will move the following. One, that the Integrity Commissioner, Ethics Advisor, Legal Services, and the City Clerk return to Council services with a report or reports about lessons learned regarding the Council Code of Conduct and the sanction hearing process, due date of Q1 2022. And that administration return to the July 5th, well, that's not going to work. That administration return with an amending bylaw to the Council Code of Conduct to hold sanction hearings in abeyance until after the October 18th, 2021 general election.
I'll second that.
That's
Okay,
notice.
it's just notice, so that notice will be debated on the 5th.
Fair enough.
Thank you, Councillor Banga, though. Okay, thank you, Councillor Cartmel. Notice is received. Councillor Paquette, are you ready to go?
Hi, thank you. That administration delay the release of the pending RFP for contracted transit maintenance and cleaning services and investigate alternative funding options to maintain the existing 61 full-time equivalencies in-house and provide a report to council detailing options and make that next appropriate meeting.
The notice is accepted that the motion may not be in order from a budget perspective the way you've presented it, so we can chat about that offline, so.
Okay, sure, that sounds good.
Okay. Any other notices today? Not seeing any, then this meeting is adjourned.